Welcome, everyone, and thank you for joining us today for our program, Corporate Transparency Act, and how does it apply to you? My name is Larry Parker, and I'm the chair of the firm's Mergers and Acquisitions team, and I'm based in our Richmond office. Today, I'm joined by my colleague, Ken Shevlin. Ken is a partner in our corporate section and is based in our Charlottesville office.
Next slide. Before we get started in earnest, we have a few housekeeping items to go over. If at any point during the presentation you have a question, you can submit it using the Q&A feature button on the bottom of your screen. We'll answer any of your questions, time permitting, at the end of the presentation. If we don't get to it then, we will follow up with you after the presentation. Likewise, if you are having any technical problems with either audio or video, please use that same Q&A button, and that will go to our marketing staff, and they'll try to resolve it with you as we go along. Also, when we finish, you'll receive a copy of the presentation materials and a link to a recording of this program from our marketing team. So there's no need to take exhaustive notes unless that is helpful to you. And so without further ado, we'll move on to the substantive part of our presentation, and we'll ask Larry to tell us what the Corporate Transparency Act is.
Thanks, Ken. Well, the Corporate Transparency Act is basically a way to sort of backfill for the United States what's done in many jurisdictions overseas. In common law countries, some countries that were that came about under the English form of law, it's not uncommon for ownership of entities to be handled in a very similar way to the way real property is here, meaning it's changes in ownership are recorded and reported through the government. There are certain things about that that are unappealing, that it slows down perhaps the transfer process, but it has been very helpful, according to our overseas partners, in tracking money laundering and criminal enterprises and anti-terrorism investigations. So for a number of years, the U.S. Congress was attempting to come up with something that would help in that regard, and the CTA, the Corporate Transparency Act, which is CTA is obviously much easier to say, so that's what we tend to do, is Congress's attempt to do that backfill. And what they've done is they've said any company, literally any legal entity, and the legal entity is anything that's files a certificate or articles in order to initiate its formation. So that includes limited partnerships, LLCs, even business trusts. Any company that is a reporting company is required to report its beneficial ownership. So then the question is, for Ken, what is a reporting company?
Right. Well, it is just as Larry described, it's just about any company. It's any domestically formed organization or any foreign organization. And the key point in the life cycle of the organization is when it files something with a state Secretary of State's office or the equivalent. So say you're forming a Delaware LLC, the moment that you file that certificate of formation with Delaware, you have to consider whether you have to report under the act. Likewise, if you were, say, some foreign company, when you're registering to transact business in Delaware or some other state, whatever the filing is that you make with the state triggers your obligation, or may trigger your obligation to file under the act. So in a sense, it's actually easier to think about what is not a reporting company. And there are about 23 exemptions. So if an exemption does not apply, then the act, otherwise, you have to comply with the reporting obligations under the act. The 23 exemptions are listed here. Most of them fall under can be lumped together as heavily regulated companies. So banks, insurance companies, securities reporting issuers is the first category on this list, and that picks up public companies, for instance. But if you are heavily regulated, the odds are good that you do not have to comply with the act. There are other exemption categories for subsidiaries of exempt entities and inactive entities as well. And then if there's sort of a catch-all for large operating companies, which refers to companies that employ more than 20 full-time employees in the United States, that have a federal tax return reflecting more than $5 million in receipts or sales in the previous year, and a U.S. physical office. And I think the impetus behind that large operating company exemption is the idea that if you are within that category, you're not the sort of entity that that law enforcement thinks is at a high risk for being some kind of money laundering operation or the like. So let's say that you can't find an exemption that applies to you, then you have to report your beneficial ownership information to FinCEN. So that raises the question for Larry: what is a beneficial owner?
Thanks, Ken. So the beneficial ownership information first is name, date of birth or date of formation, address, and unique identifying number. And as you might expect, unique identifying number is for a natural person, their social security number, or for a U.S. business entity, their taxpayer identification number. So a beneficial owner is any individual who directly or indirectly exercises substantial control over a reporting company, or owns or controls at least 25% of the ownership interest of a reporting company. So as you might expect, it's pretty easy most of the time to figure out who directly or indirectly controls 25% of the ownership interest of a reporting company. But the substantial control component is not exactly a model of clarity, and that's somewhat intentional, right? The purpose here, remember, is to capture people who are trying to circumvent government observation. So we don't want a rule that allows it to be very easily evaded. So if you are exercising substantial control, your beneficial ownership information is meant to be reported to FinCEN. The problem is there's a little bit of art determining exactly who has a substantial control. And unlike the companion rule, the banking customer due diligence rule, which was similar language and similar approach, reporting companies are required to report everyone who falls into one of these categories. So everyone who exercises substantial control or has at least 25% or more. The banking CDD rule basically says you're done once you find one beneficial owner with 25% or more. So it's a little more complicated for reporting companies. So Ken, who has the obligation to report and when do they report?
Well, the reporting companies themselves have that obligation, and then there's this term in the Act, company applicants. And company applicants is, I guess, at least fairly straightforward in theory. It's the person who actually files the relevant document with the state secretary of state or equivalent entity. So again, that could be certificate of formation, articles of incorporation, registration to transact business as a foreign entity. That sort of document, whoever actually does that filing is a company applicant, and any individual who directs or controls the filing of such a document is also a company applicant. So you could imagine in the case of a law firm, for instance, you not only have a paralegal who files certificate of formation in the state, but also the attorney who makes that happen or who requests that to happen. And you could have similar relationships no matter the company. And again, the point in time to focus on is when that filing is made with the state. So that certificate of formation or registration to transact business, that is when the obligation arises. Okay. So there's a lot to unpack here. A lot of this will be new to those of you who are listening. So you might be wondering when you have to start complying with this act. So I will turn that over to Larry to discuss that.
Thanks, Ken. So the Corporate Transparency Act becomes effective on January 1, 2024, which sounds like a long way off, but there's actually a fair amount of work to be done to get there. So any entity formed on or after January 1 must comply with the CTA within 30 days of its date of formation. So, that means you have to report your beneficial ownership information within that 30 days if you are a reporting company. Entities that pre-existed the effective date have a 1 year grace period to comply. So, that's helpful, and obviously you want to take advantage of that if you need to, but we're going to be rolling out for our clients, compliance efforts before then. And remember that any entity that's formed on or after January 1, 2024 has to comply, which means existing companies that form new companies are perhaps going to get pulled into the compliance timeline a little bit earlier than they hoped. So, Ken, how will the sensitive information be reported?
Well, I think we don't quite know that yet. That's an unfortunate reality. The Treasury through FinCEN is coming up with a system. We think it will be through some sort of electronic portal. So we'll keep you posted on that, and please look to Williams Mullen for more updates. I can tell you that Williams Mullen itself is working on putting in place systems so that we have this information when we're asked to form entities on our client's behalf. I don't think we know exactly what that looks like yet, but I think it's one thing to recognize is that it will be a market change. It's not just going to be business as usual. In the past, when somebody's asked us to form an LLC, we just go and do it. But this will require a little bit more diligence on our part and on the part of our clients, unfortunately, just to comply with this law. Larry, anything you want to add to that?
Yeah, I mean, I guess the way we're envisioning compliance is that there will be checklists that folks have to go through that look quite similar to one of the earlier slides, where they check the box, and if they ask us to form an entity, if you can't check one of the boxes that says you're not a reporting company, then you're a reporting company. So then we'll have to go through the process of a beneficial ownership questionnaire. So the other question that occurred to me, Ken, that I'll answer is who gets this information, and that's it's relatively narrow, but maybe not as narrow as you might hope. So federal law enforcement agencies, federal agencies engaged in national security or intelligence operations will have relatively open access to the beneficial ownership information for obvious reasons. State law enforcement agencies will be able to obtain it with subpoenas, and foreign law enforcement agencies will be able to obtain it if they have a treaty with the U.S. or if they are a trusted company, and that's typically going to be obtained through a U.S. federal law enforcement request. Financial institutions are going to have access to this information in order to allow them to comply with the customer due diligence rule, and that's probably going to create some interesting situations because, as we noted on some of the earlier slides, the rules are slightly different. So information reported under the CDD rule to your bank when you're filling out a paperwork to open an account will be different than what you report under this rule, and invariably that's going to slow down the process of opening bank accounts when the folks that at the bank are reviewing it and going, why this is information different. Federal functional regulators are going to have access to the information. That's primarily banking regulators, and that's going to be related to CDD compliance. And most importantly, the U.S. Treasury is going to have access to the information. So it'll be another way that the IRS can potentially focus its audit efforts. So unfortunately, we're out of time, but if you had any questions that you submitted through the Q&A button that we didn't get to, we'll reach out to you separately. But thank you all so much, and please feel free to contact Ken or myself if you have any questions about the CTA.